So, welcome to yet another market briefing at Clyde, and I wanted to thank Toby for hosting the meeting and also the lunch off, if I may, by handing over to Dominic Howe to start. I did actually ask for a quick biog of Dominic, and he tells us that he joined Clyde in 2009 and specialises in complex insurance claims and coverage issues with a particular emphasis involving property, liability, construction and contingency insurance. So it actually goes right across the piece there. He did actually start in Marsh, obviously saw the error of his ways and moved forward. He used to place sports PA and again contingency insurance policies before moving and training at Barlow, Lyden Gilbert. That's enough for me. I think, if I may, I'm going to hand over to Dominic.
Firstly, thank you for coming today on this slightly drab Monday afternoon. Hopefully my talk will be slightly less drab. Clyde's obviously worked very closely with the MGAA. They're involved closely in setting up a number of years ago. We also work on behalf of a number of its members, both in terms of dealing with their contentious claims work and also dealing with their corporate needs. Geraldine works in our corporate team and I work in our property, liability and construction team, dealing with a number of mainly property claims for MGA members. Today I'm going to talk about the future of English insurance law in light of the Law Commission's reform proposals. As you may be aware, the Law Commission conducted a major review of English insurance law, and a number of reform proposals have been in the pipeline for a number of years now. The reasons for the reform are summarised quite nicely on the slide by David Herzl of the Law Commission. Essentially, the reason for the reform is seeking to modernise English insurance law, which is based primarily on the 1906 Marine Insurance Act. This is in order to bring English law in line with other EU member states and also other Commonwealth jurisdictions. The Law Commission are seeking to strike a fairer balance between the interests of insureds and insurers. There is a view that English insurance law at the moment is weighted too heavily in favour of insurers. Whether or not that's a good thing, it's probably a biased audience here. So the reason for this is to try to ensure that London continues to be an attractive and leading international marketplace for insurance and continues to attract business. Firstly, I must say that the Law Commission's reform proposals should not be confused with the Consumer Insurance Act, which came into force just over a year ago, which relates only to consumers, namely individuals acting outside their trade or profession. Those reforms adopt a similar approach to the FOS. Finally, in terms of timing, it looks like the proposals will come through in the not too distant future. The consultation period is still ongoing, but the Law Commission are hoping to publish a bill perhaps this summer, and if so, then they're looking to get the bill enacted before the next general election, perhaps in 2015. My talk will focus on four main areas proposed for the reform. As you can see, the first one relates to disclosure and misrepresentation. Second is warranties. Thirdly is basis of contract clauses. And finally, late payment of claims. In doing so, I'll briefly first touch upon the current legal position and then summarise the proposed reforms and then discuss how it might impact upon insurers. As you will see, some of the reforms proposed are more evolutionary in nature, where the Law Commission are simply seeking to clarify the existing law and codify it, whereas some of the reforms are slightly more radical. So, disclosure and misrepresentation. As you're probably aware, a duty of good faith exists. This was originally codified in the Marine Insurance Act back in 1906. Essentially, this requires an insured not to misrepresent any material facts and also disclose all material facts to insurers. So, what is material? Well, every material circumstance is deemed material which the insured knows or ought to know in the ordinary course of its business. The test for avoidance is established in case law, set out in the case of Pan Atlantic versus Pinetop. It's a two-pronged test, so there's both an objective and a subjective element to the test. The first element is the objective side, and this requires whether the fact is a fact which the hypothetical and prudent underwriter, obviously all underwriters are prudent, as we all know, would have wanted to know in assessing the risk. This is usually judged by reference to expert evidence. So, if you're in a trial, you would have to get an expert underwriter to support the fact that it's material. But usually, it's not a difficult hurdle to overcome. Second limb is subjective, and this is called inducement, and that requires the actual underwriter to give evidence to confirm that it would have changed his underwriting decision had that fact been disclosed to him. Provided that this test can be satisfied, this entitles insurers to avoid the whole policy ab initio, as we call it, so with effect from its inception, even if there's no specific question on the proposal form, although this does help suggest it's material, and even if the underwriter would have still accepted the risk but underwritten it on different terms, such as applying a different premium. So it's plain that the test is clearly weighted in favour of insurers, despite the fact that the relevant underwriter's evidence on inducement is scrutinised very carefully in trial to try and mitigate against any sort of retrospective underwriting. Nevertheless, the Law Commission has identified a number of problems with the current law. It's regarded that the duty of disclosure is poorly understood. It's not always clear to risk managers or to insureds exactly what information would be material and what they would need to disclose. It's also quite difficult for larger companies to comply with, purely because of the amount of information they generate and gathering that information. This in turn can create data dumping, where if an insured is not sure what to disclose, they'll just disclose everything, and then it's down to the underwriter to try and find the material fact in amongst immaterial information. Again, it's suggested the law may encourage underwriting at a claims stage, so at the time the underwriter may not want to ask many questions about the risk, and then when there's a claim, with the benefit of hindsight, then he might say, oh well, I never would have agreed to that had I known this. And finally, the remedy for failure seems to be too harsh. It's very much all or nothing, even if the underwriter would still have accepted the risk, albeit on different terms. The Law Commission have made three proposals to the law in this area. The first two seek simply to clarify the present position, whereas the third one is slightly more radical. The first proposal is to make the fair presentation of a risk a central concept to the duty of good faith. The second one is to clarify what the term knowledge means and who would have knowledge or deemed knowledge. And thirdly, which is more radical, is to introduce proportionate remedies to insurers for non-disclosure rather than necessarily the avoidance of a policy. So fair presentation, the Law Commission have given some guidance on this and intend to try and codify a definition. But essentially what they say is that it's not fair to hide material information in a very large dumping of data. Most of it is immaterial. Simply, underwriters don't have the time to review 100 pages of presentation. So they have to prepare a fair summary of the risk in the way they present it. It's still also based on what the prudent underwriter would want to know as being material. However, the Law Commission now places more onus on the underwriter to ask questions if there's any information disclosed which may suggest any problems. The Law Commission has given some guidance as to what should be included. This includes any unusual or special circumstances which may increase the risk, any particular concerns, or any standard information which is usually expected to be disclosed for that type of risk. The second area is knowledge. The Law Commission realised that the 1906 Marine Insurance Act does not specify whose knowledge is relevant. The Law Commission have sought to clarify this in their proposed bill. There's two types of knowledge to distinguish here. On the one hand, you have actual knowledge, and on the other hand, you've got constructive knowledge, which are facts which that person ought to have known. In terms of actual knowledge, in relation to insureds, it will be the knowledge of the highest level management of the company, such as directors, and also the person who's responsible for arranging or placing the insurance policy. In terms of insurers, again, it's the highest level of management and also the person who's actually making the underwriting decision. In terms of constructive knowledge, for insureds, it's information which would have been discoverable based on reasonable inquiries. This will be judged depending on the size and nature and complexity of the business. And for insurers, it's information which ought to have been communicated to the underwriter. So maybe an example would be if the underwriter has access to claims information or claims history, and the systems are in place, yet he doesn't choose to access it and he doesn't find out there's an adverse claims history, then arguably he could be deemed to have constructive knowledge of that. And finally, the proportionate remedies, as I've really touched upon, the current law is very much all or nothing avoidance, or not possible to avoid the policy. Before introducing proportionate remedies, the Law Commission first distinguished between fraudulent proposals and non-fraudulent proposals. Now, fraudulent proposals also include deliberate or reckless non-disclosures or misrepresentations. If it's deemed fraudulent, then the current position on avoidance will still apply, so you can avoid the whole policy even if it would have simply resulted in an increase in premium. In terms of non-fraudulent declarations, a proportionate remedy will apply to reflect what the underwriter would have actually have done. So the underwriter's evidence on inducement is still extremely relevant, if not more relevant. In fact, the Law Commission goes one step further to ask what the underwriter would have actually done instead. So if, for example, he would had the material facts been disclosed to him and he still would not have agreed to underwrite the risk, then insurers can still avoid the entire policy. If, on the other hand, he would have simply applied different terms and conditions but still accepted the risk, then the policy is still valid, but those terms and conditions would be incorporated in the policy. Now, that might sort of assist insurers if there's a warranty imposed in the policy which may entitle them to repudiate the claim on other grounds. And thirdly, if the insurer would accept the risk but charge a higher premium, then insurers can proportionately reduce the amount of the claim by the amount they would have increased the premium. So it seems to be, certainly a fairer system now for insureds, but certainly there would seem to be more scrutiny placed on inducement and exactly how a court would decide, or whether they would necessarily accept the underwriter's evidence as to how he would have acted, may give rise to some dispute and require some further clarity. The second area for reform is the law on warranties. this area of law has received very strong criticism due to its draconian and harsh consequences. As you can see, it's been called archaic and even bringing English law into disrepute. Why is there this criticism? Well, the consequences of breach of warranties are established under the Marine Insurance Act and also clarified further under case law. But essentially, a warranty must be complied with exactly. So even if the breach is minor or technical breach, insurers would still be able to repudiate liability. It does not need to be causative to the loss. So if the breach relates to something completely different, insurers could still repudiate the entire claim. And insurers are discharged from liability altogether as at the date of the breach. And therefore, it's not possible to remedy a breach subsequently if it's a true warranty, because at the date it has been breached and the policy is no longer in force. So the consequences can be very severe and disproportionate in certain circumstances. To mitigate against this, however, in practice, the courts do scrutinise the clauses very closely to see whether it goes to the root of a contract and whether it's deemed to be a true warranty. They may therefore apply some creative reasoning at times to do justice in individual cases, and therefore may downgrade what's termed as a warranty to a mere condition or a suspensive condition. Nevertheless, this still leaves the insured too often at the mercy of the courts or even the goodwill of insurers who may not decide to enforce a non-causative breach. However, this still leaves some uncertainty in the law because this may give rise to an inconsistent approach. As you can see, the Law Commission have identified 3 key problems which I've touched upon. So insurers may refuse claims for trivial mistakes. It's not possible to subsequently remedy the breach, even if the breach is no longer being breached at the time of the loss. And the breach discharges insurers from all liability, so not just liability for that loss in question. So if you have a warranty relating to fire risk and there's a burglary claim, you could still decline the burglary claim. So the first proposal is that warranties should become suspensive conditions. Therefore, provided if an insured has breached the warranty and provided he remedies that before the loss takes place, then liability will be restored. The Law Commission argue there's no logical reason why breach should necessarily be fatal, however minor, and it should not be impossible to remedy a breach. An example of this may be a burglar alarm warranty, which has a requirement to inspect it every 6 months, and the insured does not carry that out until the 7th month. In that case, if the loss fell between the 6th and 7th month, the insured would still be in breach, so insurers could still enforce a warranty. Whereas if the loss occurs after the 7th month, then liability would have been restored because the breach would have been remedied. The second proposal relates to if a warranty is breached, it's only possible to decline a claim for a loss of the same type as what the warranty is designed to guard against. An easy example here would be a sprinkler warranty. If the warranty was breached, insurers could not therefore decline a claim relating to burglary. However, they could decline a claim relating to fire. Even if it does relate to the same type of loss, it still would not need to be causative. So in terms of the sprinkler example, if the sprinklers wouldn't have had any effect on putting the fire out, they could still rely on the breach of warranty. So to summarise, therefore, it seems with the Law Commission's proposals it will be okay if provided the breach has been remedied before the loss. However, to enforce a warranty, it must relate to the same type of loss, although the causal link would still not be required in those circumstances. This gives rise to 2 potential issues, which is good for lawyers, I guess. Firstly, what exactly does remedied mean? If something's been partially or substantially remedied, would this be sufficient? the wording used by the Law Commission in the proposed bill refers to a risk being remedied if it's essentially the same as prior to the breach. It's not clear exactly what essentially the same means. An example might be if a burglar alarm warranty was not complied with, and instead of inspecting or upgrading the burglar alarm, the insured decides simply to appoint 24-hour security. Would that be regarded as remedying the breach? It remains to be seen what approach the courts will have on that. Secondly, whether a term relates to the same type of loss. Again, what is the same type of loss? Some cases might be clear-cut, others there might be some grey areas. Again, this will be a matter of construction. An example might be a burglar alarm is not being maintained properly, and there's a fire claim which is thought to be arson. Now, technically it's not a burglary claim, but and it relates to a fire claim, but had the burglar alarm been functioning, then it may have reduced the chance of the arson occurring. So although the proposals are quite far-reaching in their effect, I would question how much it will necessarily impact it in practice. In our experience, most insurers we deal with tend not to find it commercially attractive to enforce non-causative or breaches of warranty or ones which have been remedied prior to the loss. One benefit of the current approach in the law is at least it gives insurers the option to enforce technical points. For example, if they have concerns about the probity of the claim, it's open to them to take a more technical point. So the reforms are likely to minimise that. I'll briefly touch upon basis of contract clauses. Essentially, as you're probably aware, basis of contract clauses seek to convert minor misrepresentations into warranties under the policy. They're usually found either in the as a declaration of proposal form or in the policy wording. As I've touched upon on warranties, as they warranty that the information in the presentation is true, if there is any part of it is wrong, even to a minor extent, this would technically entitle insurers to repudiate liability for breach of warranty. This also gets around the need for insurers to show materiality or inducement, which would be required were you to want to avoid the policy based on the test, as I touched upon earlier. This is certainly blanket basis of contract clauses have been heavily criticised, although they still are valid law. The Court of Appeal fairly recently upheld a basis of contract clause. However, the Law Commission proposed to abolish basis of contract clauses entirely. This is a very popular proposal, and it seems to follow the Consumer Insurance Act, which has already abolished their operation. Nevertheless, it may still be possible for insurers to make specific issues or specific representations into warranties, although this would have to be specifically agreed and pointed out to the insured if there's some material information which is extremely important to the risk. Finally, late payment of claims. Under the current law, it's not possible for an insured to bring a claim in damages owing to the late payments of a claim. However, the Law Commission are proposing to make it a contractual obligation to pay claims within a reasonable time, and the failure to do so, therefore, may give rise to damages for any foreseeable losses. The issue will be what is a reasonable time. This will depend on all the circumstances, including the size and complexity of the claim. However, insurers will still be entitled a reasonable amount of time to carry out their investigations of the claim. It would also be okay if, for example, insurers decline a claim and later they find out that their decision was wrong. Provided they've acted reasonably, then this should not hopefully cause any issues. However, this proposal does create some uncertainty because it won't necessarily be clear at the time whether or not you've acted within a reasonable time frame. So it may not come to light until later down the litigation process, perhaps even at trial. And secondly, this may impact upon MGAs. Obviously, if the claim has been dealt with by the claims handler at the MGA, if for some reason they cause any delay in the settlement of the claim, this may cause some issues with their backing insurers who would be liable to pay for any foreseeable losses caused. So this could give rise to some liability issues for the MGAs. Finally, the Law Commission's proposals are very much intended to be a default regime for business insurance. So therefore they enable parties to have the option of contracting out of the reforms if they wish to do so. However, in order to do so, it must be clear and unambiguous that this is being done, and also it must be sufficiently brought to the policyholder's attention. Now, this means that the policyholder must be given a reasonable opportunity to understand the alternative terms, so you could basically contract still on the current law, provided he's made aware of the consequences of contracting out. And the extent to which it must be brought to his attention will depend on the sophistication and status of the policyholder. So insurers will probably need to do less to bring it to the attention of a more sophisticated client who's represented by a broker than a small business. It's even been suggested by the Law Commission for more sophisticated clients who have a broker, simply verbal notification may suffice. In doing so, the Law Commission seeks to strike a fair balance between the interests of insurers and insureds. Although this may give rise to two potential issues, it may create a bit of a two-tiered system. So larger, more sophisticated clients will probably be better represented and probably have more leverage in the market. So even if insurers wish to contract out of the provisions, they may have little power to actually do so. And the concern that this may cause some uncertainty because even though insurers think they may have successfully contracted out of the provisions, this may be challenged by the insured perhaps, and it may not come to light until the actual trial whether or not they've been successful in doing so. So in summary, therefore, the Law Commission's proposals will create proportionate remedies for misrepresentation and non-disclosure. Technical breaches of warranty will no longer be necessarily enforceable. Blanket-based of contract clauses will be abolished, and claims will need to be paid within a reasonable time. However, in certain cases, it may be open to insurers still to contract out of the reforms. The proposed reforms may give rise to some issues which insurers should be conscious of. So, for example, on the underwriting process, underwriters may need to be a bit more proactive about asking follow-up questions, and also proposal forms may need to be more comprehensive in the questions they ask. And also it may be possible to get round the reforms on the warranties with some clearer drafting, such as specifying exactly when insurers will not pay the claim. So although possibly this is the biggest reform to insurance law in 100 years, it remains to be seen how the law proposals will be interpreted by the courts. And in any event, a number of them are evolutionary and followed as good practice by the market at the moment. That's the end of my presentation. If you have any questions, please feel free. Oh, sorry.
Sian Fisher from OIM. So you said at the beginning that part of the drive of this was to bring our slightly antiquated insurance law more in line with the European market or the international market.
Yes.
I mean, as Clyde Co, you obviously see a lot more of that than we do, probably. I mean, what's your view? Is this correctly directed, or is
I
it
think
just
so.
tinkering?
I think English law is slightly behind, certainly the European countries and jurisdictions in terms of treating insureds fairly. The Australian and Commonwealth jurisdictions are already ahead of us. It's been, I think, for a number of years, it's been proposed, and it's not been until more recently these proposals have come into force. But in Australia, for example, they've been in effect for about 30 years now, even though, again, Australia was based on a very similar system to ours. So I think it does strike a fair balance. However, unfortunately, it does dilute insurers' power somewhat. So, as I touched upon earlier, you might not have the same technical defences as you once did if you suspect something untoward about the claim. So, but at the moment, I guess the law relies on insurers acting diligently and not abusing their sort of greater power, I guess, in the case law. So,
Lorraine Sheehan from K. This is a question from one of my colleagues who couldn't come. Taking it up to the next level in terms of treaty reinsurance, a lot of companies want to do business via London and English and Welsh law. Do you see this having an implication on our reinsurance business? Will companies want to go elsewhere?
I mean, firstly, I'm not a reinsurance specialist, but I think English law is internationally regarded as has been a very safe haven for insurers, and it's quite a certain jurisdiction. And despite the slight watering down of insurance law, I still think it will be a very attractive marketplace for insurers, and where they still have certainty in law. Now, some of these proposals, it may take a bit of time to clarify some of the concepts, and there may be some case law debate, but overall, I don't think it will have a great deal of impact.
Any more? I had one quick question, if I may, Dominic. You talked about the knowledge, and obviously if you have an MGA who is dealing with a specific type of business, let's say cyber liability, knowing the broker submission coming in and taking aside the blind eye defence, do you think that the specialist has anything else to do in relation to the information that's coming forward, because the people who are feeding into them may not fully understand what they are expecting?
So in terms of the specialist being the underwriter or the broker?
Yeah, especially being the MGA.
Yes. Again, I think it would probably help if there was more direction. So in terms of proposal forms, I think if you specify exactly what information you require, obviously the insured might not be in a position to know exactly what's relevant to the underwriting of the risk, although the broker should have a better understanding. So brokers should maybe cooperate closer with insurers to work out exactly what information would constitute a fair presentation. So, I guess we're conscious not to data dump and not to provide everything, but it seems the concept of fair presentation and knowledge will still...
Well, one of the issues that came out of CEDRA was the fact that there could well have been an underwriter with a particular view, and let's think of flood. And then when that went through to somebody else's proposal form, that had changed from how far away from a particular area. So the clause in itself was asking a similar question, but it wasn't the same. So are you within 200 metres, or are you in a floodplain as designated by the Environmental Agency? I can see that sort of issue coming down as well. So as an MGA, we need to make sure that the question sets that we're asking our client base, being brokers, is exactly the same as that which the underwriter would be asking. Is that right?
Correct. I think there'll be certainly more onus, especially with underwriters as well, having to follow up on any concerns, or where it's not entirely clear. They can't simply just bury their heads in the sand and think, oh, well, if there's a claim, we can sort it out, and if they haven't disclosed everything, then we can avoid. I think it's going to be more difficult to do that. So I think there'll be more impetus on trying to be a bit more proactive and trying to, I think to that extent, it will help, trying to standardise as many proposal forms for that area. So you don't have proposal forms from one broker which ask certain questions, and another one which has other, different form of wording, because otherwise the underwriter will have to try and clarify more and more. So if the proposal form itself is worded carefully and is comprehensive, then the underwriter will be less likely to need to actually have to follow up.
So there's a standardisation flowing back through this potential change then?
I would expect so. I think in light of the proposals, it's probably in the industry's interest to try and make the proposal as comprehensive as possible. Well, at the very least, I think if there are any concerns, I think there will be an onus for insurers to have to follow up for any areas they're not clear about or any concerns they may have.
I'd like to pass over now to Geraldine, who has experience in providing regulatory and restructuring advice for clients within the insurance sector.
Yes, I'm Geraldine Quirk. I'm a partner in the corporate insurance team at Clyde Co. So we do spend, for our sins, a lot of time looking at and advising on regulatory issues. I mean, it's impossible to do anything in this sector in terms of any kind of transaction without understanding regulations and without dealing with the regulators and now two of them, which adds another level of interest and time to everything that we do. I mean, one of the things whenever you're sort of approaching talk about regulation really is to know where to start, because there's just so much out there and it's ever increasing. I could be standing here all afternoon talking to you about things that are coming out of the FCA at the moment. In the last 12 months, there have been an awful lot of publications from them in terms of thematic reviews and market studies as they really try to get to grips with their new role and try to demonstrate to the market that they really are a strong and powerful regulator and are doing what they're supposed to do and are a force to be reckoned with. So there's been an awful lot for everyone to analyse and keep up with and understand in that 12-month period. One of the things they have published just recently, which is actually fairly helpful, is they've done sort of little individual guides for each of the 4 categories of firms, so from C1 to C4. Setting out what their approach to regulation for each of those firms is, and for a wonder, these are actually quite brief documents. They're not the sort of the War and Peace stuff that you sometimes used to get from the FSA. So they're quite approachable and quite easy to read. As you might expect, they've sort of set out at the top what their 3 objectives are, which are protecting consumers, preserving the integrity of the UK financial system, and promoting effective competition, and then what their approach in dealing with those objectives is. They have this 3-pillar approach. It doesn't seem to be possible for any regulator to do anything in regulation without having pillars these days. So whatever it is, there are always some pillars to be reckoned with. The FCA have 3. The proactive supervision, which is when they're actually coming in, visiting firms, understanding and sort of challenging their business models, and sort of making sure that senior management are accountable for everything that happens in the organisation. Then they have the reactive work, which is basically if something goes wrong, if they identify a risk, how they're going to prevent that causing harm, or if there has already been harm, taking enforcement action to deal with that. And then the issues and products work, which has been a really increasing area for them, and which is where all the things like the thematic reviews and the market studies come from, which is sort of part of their drive to deal with issues at the front end rather than coming along like the FSA did and having to tidy up after everything has gone wrong. So they want to be sort of proactive and identify issues before they actually cause any problems, so that they can prevent any consumer harm. So what they focus on for any kind of firm, doesn't matter what size it is, they'll be looking at the sort of the business model and strategy, and they'd expect the board, for example, to be able to explain that each individual board member and members of senior management to understand what the risks are that arise from that particular organisation's strategy. For example, if the focus is on growth, what are the risks that arise from that from a consumer perspective? Are you sacrificing the consumer interests in terms of just to increase growth and gain profit? Have you realised that, and what are your controls that are in place to address that? And they would expect senior management to be able to sort of articulate and understand that. There's a big emphasis on culture, on ensuring that customers are fairly treated in absolutely everything the firm does, and that's really demonstrated right from the board level down. And they've made sort of various pronouncements in speeches right from when the FCA started out back in April about how A lot of firms' culture has been around profit at the expense of the consumer, and developing products that don't really address consumer needs. It's been really an emphasis on money rather than treating customers fairly. So there's a very big culture is a very big sort of theme for them. They want to look at the frontline business processes, so it's everything from product development to how you sell it to how you deal with complaints and claims. Obviously, systems and controls have always been a big theme, right back to FSA days. But they want effective independent controls in place so that there's actual sort of challenge provided to business units from those control areas. And so that the senior management have assurance that everything is, things are being properly controlled throughout the business. And then finally, one of the major themes is governance. I mean, obviously, for all of the first 4 bullet points there, the board and senior management have got a key role in determining what each of those areas are and how they work. So they're really key to making sure that a particular business is going to comply with the FCA requirements. So governance, pinning responsibility on senior management and on the board is a sort of huge theme for the FCA and an increasing one. They've set out these 10 supervision principles that also in these recent papers they've published, which I'm not going to go through all of them in detail. But really the first 4 sort of address the point that I talked about trying to look at the significant issues that are actually going to affect consumers and try to look at them early before any problems actually develop. So they want to identify the risks and take action to prevent anything from going wrong. And they say that they're going to be sort of really focusing their resources on the big issues and causes of problems and being less of a sort of a box-ticky type regulator like the FSA. I'm not sure really how that's actually panning out in practice. This is still a big feature of all their policy pronouncements and speeches, but when you sort of hear about the kinds of questions that people visiting from the FCA are asking, you do sort of wonder whether they've heard these speeches because, for example, we had a client who was a reinsurer who had a visit from the FCA, and one of the things they focused majorly on was what are your complaints processes. Now, for a reinsurer, I'm pretty sure every one of their cedants would not be backward in coming forward if they had a particular issue with the way their reinsurer was behaving, and they don't need the reinsurer to tell them how to complain. So that was a very odd area for someone to be focusing on. You can completely understand that in a consumer business, but in an insurance business or with a broker dealing with the man in the street type client, but that was just it's a very, very odd thing for them to be doing. So it does suggest that there's some kind of disconnect between the people setting the policy and making all these speeches and pronouncements, all of which sound, very sensible way to approach regulation, and the people that are actually doing this at the coalface. Another point they make is that they're expecting firms to act in the right spirit, and that's how they will be directing their efforts. So it's not about compliance with the letter of the rules. It's about looking at what is the intention behind those rules and working out, how the actions a firm takes are going to impact a customer. So you can't now say, well, I've looked at ICOBs and it says blah, and that's what I'm doing. And actually, for our business, that doesn't really work that well in practice, but that doesn't matter because I comply with the rule. That's not going to wash. It has to be, you have to look at what the actual impact is going to be on your customers. Emphasis on individual accountability. Again, this comes back to personal responsibility of senior management, which is a huge theme. And being robust when things go wrong. I think we've seen that from the level and frequency of fines and enforcement action that have happened in the past year. They're certainly following up on that one. And again, communicating openly. Sometimes I sort of wish there might be a little less communication from the FCA just to give everyone a breathing space, but there's certainly no one can be in any doubt about what their objectives are. They're very clear with that. They publish in the back of their business plan for the next year what it is they're going to be focusing on. So I think they are clear about their sort of aims and objectives. Right from the outset, you can pick up from the speeches that Tracey McDermott made. I mean, these date back to sort of the beginning of the FCA's reign. All those themes have been picked up. The determination to create a culture of good conduct, being more proactive, interventionist and judgment-based. Talking about cultural problems where the interests of customers were an afterthought, it being profit and growth being the main thrust. And again, the emphasis on being able to make senior managers responsible. So they're saying, she made the point that finding the firms alone is not enough. They now need to look at taking action against senior management individually rather than just looking at the firm. And you can look at the level of fines that were imposed last year. It's 423.2 million in financial penalties in 2013, which is quite a chunky number. 14 million in redress and 43 individuals prohibited. So they've really sort of opened, they're flying in that year. Obviously, all of this additional work that they're doing has an impact on the costs of maintaining the regulator. And if you look at the budget for last year was 445 million, and that was already 83% of the FSA's budget for the year before. And when you think we've got to add on top of that, PRA in terms of what regulation is costing the industry, that's quite an increase. And the budget for this year has gone up by another 7 million for the FCA, and they put that down to IT systems, taking over the consumer credit regime, which they're now responsible for from April, and increasing their headcount. And that is really not surprising, because one of the things that they themselves flagged up at the outset was that if you're going to have a regulator that's going to be making judgment-based decisions and going in and understanding a business and effectively second-guessing what management who have years of experience in the sector are doing, you need to have really good quality people who understand the industry. So they're going to have to spend some money on attracting people who are able to carry out those roles and making sure they have the resource to do this in a way that's actually, that actually works. So I don't see the budget coming down anytime soon, I'm afraid. Looking at the sizes of the fines that have been imposed over the last year, I mean, not all of these aren't all insurance industry ones, but they do, the ones that aren't do have sort of themes that play across into whatever financial services sector you're in. So, I mean, the Prudential one, that 30 million fine, that was technically, it was a breach of the listing rules was one of the issues, but another one was failing to be open and cooperative with the regulator was one of the issues that they were fined for. Swinton, that 7 million fine was to do with telephone sales of add-on products, obviously add-ons being a very hot issue for the FCA at the moment, and that again having a strategy that was geared to profit, but right throughout the process from designing the product, selling it, it was all to do with profit and not to do with actually looking at what a customer needed, and the products were basically in the FCA's view missold to a lot of customers who didn't really understand what they were buying and didn't really need those products. What else do we have? And the JLT specialty one, 1.8 million, that was to do with bribery and corruption controls. And some of these fines, I mean, they're quite big figures, but they're not necessarily imposed because something has actually gone wrong. So, you may find a case where the fine is because of anti-bribery and corruption controls not being strong enough, but they haven't identified any payment being made that's actually inappropriate. The issue is just not having systems and controls in their view, which you can say will definitely prevent any inappropriate payments happening. So there doesn't even actually have to have been any detriment to anybody in order for a fairly chunky fine to be incurred. I think that's an issue that some firms say, well, we've never had a problem, it's never really gone wrong. That's sort of not the point. You need to have the processes there in order to be able to keep the FCA happy when they come to call. We're going to look a bit more at the HomeServe fine in a minute. That one does pick up a lot of the FCA regulatory themes, and it's obviously quite a recent one, and the biggest retail fine I think there's been yet, 30 million. So we're looking at 472 million fines in total in 2013, and already so far they've got to 85.2 million in 2014 in terms of fines. The HomeServe fine, as I said, it was 30 million. It was actually reduced from 43 million because they sort of settled early, basically. So you can get a reduction on the fine if you do that. Sort of put your hand up and say we acknowledge things have gone wrong. And they've also had to pay 16.8 million in redress to the customers that they were missold to. There were 69,000 of those customers. And one of the major issues here are misselling, and a huge factor in that was felt to be the remuneration structure for the sales staff, where basically They were incentivised to sell as much as possible and not really think about whether or not the customer actually needed the product. And that was made worse by the fact that a lot of the sales were to people of retirement age, so the FCA felt that they were really targeting sort of more vulnerable people, which didn't go down particularly well. And they just hadn't explained the price and coverage that these products offered and whether it was something that actually gave any real value for money. Obviously, remuneration and incentives is another thing that the FCA is focusing on at the moment, and a thing that they've said they will be focusing on in the year coming forward, and looking how incentivising staff can have a negative effect on outcomes for customers. The focus on senior management, again, they felt that none of the senior management had really had any training in compliance and regulation, so they were just basically incapable of identifying what TCF risks might have been. They didn't have any regulatory knowledge, and even when they got compliance reports through that suggested that there might have been problems like misselling, they didn't pick it up because they just didn't have that mindset. So there were sort of failures there at the senior management level. And the way that complaints were handled, again, that came back to remuneration structure. Basically, complaints handlers were incentivised just to get rid of as many as possible without really thinking about, and without offering any redress to the customer, without really thinking about what had gone wrong from the customer's perspective. So, they weren't offering appropriate redress. So, I mean, all of that is a sort of a fairly big breach of from the FSA's perspective of TCF principles, basically, and it does illustrate a lot of the things that they're really going to be focusing on. In terms of looking at individuals and management, I mean, one of the things that's increasing now is their use of these nasty little creatures called attestations, where they will ask a particular individual, or it might be the whole board, to attest to the way a particular aspect of the business works. So they might say, we want you to sign a statement saying that your claims handling process achieves X, Y, and Z. And one of the reasons for doing that is, I think in FSA days there was a feeling that it was very difficult to actually take action against senior management because they were too far removed from where something had gone wrong. So if something went wrong in your call centre, who in senior management could you really take any kind of enforcement action against for that? They were just a little bit too far removed from the action. So if you get someone from senior management to actually sign and say, this is how our processes work in practice, and then there's an issue, then that individual obviously has a bit of a problem and is in the frame, really, for some form of enforcement action. So it does increase the risk of individual enforcement action against managers, and it's something that, if you were ever asked to sign something like that, you'd have to be pretty careful on the due diligence to make sure that you could confidently make that statement. There's also the risk of being sort of dragged into committing the Section 398 offence, which is knowingly or recklessly giving misleading or false information to a regulator. So if you sign one of those attestations without really checking out whether you can support it, then there is a risk of that offence being committed. In terms of enforcement, the FCA have said they're going to be interviewing senior management a lot more than they used to do in their enforcement and investigation processes. And they're no longer prepared to sort of give a clean sheet to senior management. The FSA used to, if they'd fined the company, sort of say, right, that's it, we'll start again, and we're not actually then also going to take action against individuals. We'll sort of put all this behind us and carry on. And the FCA said that they're not prepared to do that now. And there's also this practice of publication of warning notices. So when they're deciding to take action before a firm has even had a chance to respond to any notice from them about what they think might be going wrong, they can publicise that now. When it comes to individuals, though, they do that anonymously, so they won't name the person, and if it's a problem with an individual, they also won't name the organisation, so you can't guess who it is, because they acknowledge that can have a pretty negative effect on an individual and their career prospects if they happen to be named in that sort of action. And again, in terms of governance, they expect senior management and board members to be able to explain what the conduct risks are in their business, that those have been identified, and what they're doing to address them. They want to have a culture where you sort of implement consumer and market-focused values rather than being all about growth and profit. They will expect the board and senior management to look at things like high-return products and business lines and analyse why they are so profitable. So it's not just a case of, excellent, it's profitable. You have to look at, why is that? Is it because people are buying it and not claiming because it turns out it doesn't actually address a need that they have, or they don't understand it? Do we need to change the way we're selling it? Is that why the loss ratios on these are so good? And also look at the way products are targeted. So for something particularly complex, it probably wouldn't be appropriate, for example, to put it on a website. The way that you're selling these products and who you're aiming them at has to be something that is thought about at senior level as well. And in terms of product governance, when they published a paper, I think it was actually April last year, on behavioural economics, which is it's quite a chunky publication, and it's not the most exciting document ever, I have to say. It's not a page turner, but it basically looks at analysing why it is that consumers make stupid decisions, and what it is how a firm might exploit that in order to sell more products, and how a regulator can recognise those issues and try and put rules in place to stop that happening. And there's a sort of a suggestion that they're also expecting firms to think about behavioural economics when they design products and when they decide how to sell them. So to think about whether things like a default bias, if a box has already been ticked, then a consumer is unlikely to untick it. Are you taking advantage of that in offloading a product that actually isn't going to give value for that particular person? And there's also sort of the kind of emotional thing. People buy products for peace of mind, whether they actually need them or not. There's a question over whether that's a bad thing. If that makes you feel happier that you've got that insurance in place, even if you realise it's highly unlikely you'll ever need it, why is that necessarily wrong? But the FCA is expecting firms designing products to give sort of a thought to these sorts of issues. And basically, there's a concern that firms have in the past profited from sort of consumer errors and exploited the mistakes that they make in order to sell more products and services, and that's the thing that they're trying to address. And they also think that things like insurance add-ons are going to have a big effect on competition, and they've produced their market study on general insurance add-ons, and one of the things they say is that if you're buying something at a point of sale, then you're not going to shop around. You're also not necessarily focused on the insurance product you're buying. You're buying a lovely new car. You're very excited about that. You just, you don't really focus on the insurance products that are being added on, and whether you're, being sold something extra to protect your alloys that you don't really care about, or to protect an extra chip in the paint cover. You're not really thinking about that because you're focused on the main purpose of your visit to the car dealership, which is not to buy insurance. So they're looking at ways in which information should be presented to customers to make sure they realise that they are actually buying an insurance product. One of the things the add-on reviewers found is that you could talk to people a couple of weeks after they've purchased a product and they've already don't realise they've got it. They've got no clue that they bought an insurance product at all. So they kind of represent poor value to money, whether because that consumer was never going to have a claim really that they could claim for under the policy, or because they just forget they have them anyway, so they don't claim on them. So they come up with a number of potential solutions to deal with those issues, like having a deferred opt-in on gap insurance cover. So you can't buy it actually at the point of sale. You've got to wait and then decide whether you want it. A ban on the pre-ticked boxes, so no automatic opt-ins. Also requiring firms to publish claims ratios for particular products, so it's pretty obvious when who a product is more profitable for. Whether it's paying out quite frequently or whether it just makes a lot of money for an insurance company. And also they have a concern on the way these products are sold through price comparison websites as well, and about the amount of information that's available on those websites for these products. So they're going to be looking at putting rules in to deal with that. So really, all of these issues they're expecting firms to bear in mind right throughout the whole process. So when designing a product, does it address an actual need, and is it designed to benefit the consumer? When you're looking at how these are marketed and distributed, are they targeted at the right customers, the ones that are actually going to need it? Are you targeting vulnerable customers, like in the Swindon case, in which case the way you sell it might need to be sort of beefed up to make sure they really understand what it is that they're buying? And are you selling it through an appropriate channel? So is a website type sale appropriate, or should it be really through an intermediary or a broker? And you can't sort of leave it there. They also expect sort of ongoing product monitoring. So looking at complaints data, for example. If you look at complaints, does it show that most people who bought this product thought it covered something that it didn't, and they're now complaining because they weren't covered for that. Does that show that there's a fundamental misunderstanding about what that particular thing was meant to cover? And claims, again, if it's a really profitable product, can you justify that without it, being apparent that really that profit arises from a misunderstanding on the part of the consumer as to what that product is meant to cover? So it's a sort of continual monitoring process, and then feeding that data back into the design phase of any new insurance product that's offered. I have put on the slides as well, which I'm not going to go through, but just a list of what is in the business plan for the next 2014 to 2015, and the things that they're going to look at. And these are all insurance, general insurance and life insurance, and some things that are sort of across the financial services industry, like resilience against cyber attacks and managing the performance of staff. So there's quite a lot coming up over the next year for people to get to grips with, which is going to add to the cost and time that firms need to spend on compliance. But I think that's been a theme for probably the last decade, really, ever since the FCA came in. So no surprises there. I think I've just noticed that the fourth quarter has dropped off the back. But I think there's enough with the first 3 quarters anyway to show you and give you an idea of the scale of what the regulators are going to be doing. That was all I was going to say, unless anyone's got any particular questions.
Do we have any questions from the floor?
So this is quite invasive, as in it's very directed at certain things. What are they actually going to do with all this stuff? So they're going to run around and they're going to look into all these things, most of which I think we would recognise as probably being quite good things for them to look at.
Yeah.
But what are they then going to do with what they find?
Well, it depends. I mean, in product type terms, they can start. They've got all these sort of product intervention powers. They can start banning particular features of products or requiring them not to be sold in a particular way. I think they've done that already in relation to unregulated collective investment schemes. Obviously, not an insurance issue, but they have said that those can't be sold to sort of man-in-the-street type consumers. They can't be marketed in that way. So those, in general market-wide terms, those are the sorts of things they're going to be doing for products. If they identify something that they think creates a particular issue, then they will start imposing rules about how it can be sold, who it can be sold to, and what sort of information is given to people who are buying that sort of product. They do sort of seem to recognise in their behavioural economics paper that actually more is not necessarily better. So deluging a consumer with loads of information and disclosures just bores them rigid. Most people just look at that and think, I'm not going to plough through it. So it would actually have the opposite effect to what they want to achieve, which is properly drawing their attention to what the key risks are. So hopefully we might see a reduction in the amount of paper that people are expected to churn out as part of the sales process. So that's sort of more on the preemptive side in terms of product sales. I'm sure they will be taking more enforcement action against individuals, and they are going to be really looking at demonstrating that senior management and board members in particular have got to take responsibility for these issues. So I think, in the same way that they have with fines generally on firms, they'll be looking at, possibly making some examples of people to demonstrate that they really mean business in this area, which is a slightly uncomfortable position to be in. But they generally say, look, we tell you, we're absolutely upfront about the things that we're looking at and what our concerns are. So you need to look at that. You need to look at the enforcement action that we've taken and the reasons why we've taken it, and then have a look at your own business and decide if you've got the same sorts of issues and do something about it. And if you don't, then that you're not really running the business appropriately. So I think keeping an eye on the enforcement action, and then obviously they're very public about that, and thinking is there anything in that is a lesson to be learned for our own business is going to be very important as well. They will like that.
Thank you. Do we have any more questions from the floor? I've got one question. I'm not sure whether or not you could answer this. We've seen this point of sale prohibition on PPI. We've seen what that's done to it. So there are now probably thousands of people out there that could have benefited, now no longer going to. Obviously one understands when you look at gap insurance, and maybe leave it on, but do you think they've actually thought about the integrity of the market and the capability of the market if they put a point of sale prohibition on all add-ons?
I don't think they necessarily do tend to think about that, and they're more about they tend to see the harm that has been done rather than actually the benefit that a consumer might have got from that product. Sometimes I think they think more about, well, this is terrible. All these people have bought something they didn't actually need, without necessarily focusing on the fact that there might be lots of people who do need it, and if you prohibit it at the point of sale, they won't necessarily remember that they could have had it, because consumers are lazy about this sort of thing. You don't think about insurance products necessarily because they're not the most exciting thing to buy. And I think one of the things they are talking about addressing is this issue about consumer understanding and knowledge of financial services, and knowing, being a bit savvy about what you actually do need to have and should have. I mean, they're particularly concerned in terms of things like, pension provision, obviously, because that has an impact on the state having to provide instead. But I think, they do acknowledge that there's some work to be done there, but I think they're not really sure how to go about it at the moment, because it's quite difficult to educate people in that kind of thing if they're not really interested. I mean, how do you persuade the man in the street to be sort of fascinated about PPI cover? It's just not.
That's got to be beyond the remit of the FCA.
Well, I think it is, and they do say, we're not supposed to be a nanny kind of regulator. There has to be, consumers have got to be responsible for their own decisions. But I do think there is a sort of a little way to go in how it is that firms can say, well, all right, we're not going to sell you this at the point of sale, but we should be able to contact you after 14 days to say, by the way, you bought this, are you aware that this insurance product is available and this is what it will do for you, and market things in that way.
Okay, thank you for that. One last question from the floor? No. Okay, let me bring this to a close. Thank you, Geraldine. Thank you, Dominic. Really fascinating. As you can see, there's quite a lot going on, and it's really good to have our friends at Clyde come out and talk to us about it. So will you please join me in thanking Dominic and Geraldine.